Employee handbooks and HR policies. An employee handbook is just a collection of policies regarding time off for employees, hours, compensation, holidays, and all these different rules and guidelines that are needed for employees as it relates to their employment in the company. Now, those are usually different from standard operating procedures or instructions that might relate to how to do a job. So, for example, you might have a standard operating procedure or a document that explains how to do something like ordering a product or providing a service to a client or handling the processing of payments within your company. But when it relates to human resources, for example, holidays, work hours, how to handle sick time off or vacation time, what are the expectations for employees when they come to work, and how they treat each other. All of those usually go into human resource policies, and a collection of policies is what we call an employee handbook. So, usually when you get to be about 8 employees, maybe 12, is when a company realizes we need to have all of our HR policies in writing and clearly communicated to everybody. And it's because usually when you get to about that size, the company starts realizing the owner, the founder, is less connected to each employee, and statistically, with enough hires, you're going to start running into some bumps and some problems and some challenges. And those challenges can be avoided or at least minimized by having human resource policies collected together in an employee handbook. There is a common mistake in this area. Sometimes business owners say, hey, I'll just put all these rules in a contract for employment. So the next time I hire somebody, they'll have to agree to all of these rules. But the problem with a contract is a two-sided agreement. So if you decide to update the rules or change the rules in the future, in a contract, it requires the other party's consent. They have to sign off on it. So HR policies, or like an employee handbook, you can update at any time. You don't need anybody's consent. Now, they don't need to stay with you. They can leave employment. But the benefit of an HR policy or an employee handbook is that you can change it whenever you want, and then the changes don't need approval from an employee. They simply apply from that moment forward because you are the rule maker in the company. So you might say, well, when are circumstances when you would want an employee agreement or a contract? Usually that's if you want to have the employee bound to the terms after the employee leaves. That would be the case with a non-solicitation provision, a non-compete provision, or some sort of confidentiality provision where you're asking employees to keep confidential something after they leave the company. But for most businesses, that sort of agreement is not required, and so you can simply put it in the employee handbook. And when I say it, I mean any of the rules or requirements that you have within the company. Now, by law, you're not required usually to have an employee handbook, but the law may say, like it does in Minnesota, that if you do have an employee handbook, you have to put certain stuff in there. So that's something to check with your state attorney. An attorney in your state can help you identify if you have an employee handbook, are there certain topics that you are required by law to cover in the employee handbook. For an employee handbook, you might wonder, where do we go to get something like that together? Well, usually when you're small, you just start with a few different policies, whatever you determine is needed for the particular people that are working there. Every company is so different. Some companies have a lot of very experienced people, like a small law firm or medical clinic, And then you might have something like a fitness facility or athletic club where you have a lot of young entry-level type workers there who are just working on an hourly basis. So a couple of different ways you can go. You can use artificial intelligence to create the policies you need. You can see if your industry has some sort of recommended template or policies for your type of business. Sometimes companies that you work with, like for payroll, have a inexpensive option to use a template for your business. And usually what's important there is you want to make sure it's customized for your state, because every state has different laws and requirements as it relates to employment law. Then finally, if you want, you can hire an attorney to put something like this together. Usually an attorney will use a template that the attorney has either refined over the years and maintains herself or himself, or the attorney might use a template provided by the State Bar Association. That's the case here in Minnesota. Attorneys in Minnesota can buy a template from the State Bar Association's affiliate that handles continuing legal education. Once you purchase that template, you can then use that to modify that for your clients. Let's talk about hiring. Hiring is one of the most important ways to keep the wrong people out of your company. Thinking about what the expectations are in the company, what your core values are, and being able to have conversations around that so that you can identify which people would fit well with your values and your sense of mission and the way you operate. There are a lot of books on that, but I'm going to stick to the legal pieces here. The one thing that's really important is when you screen applications or you interview people, obviously you can't have questions that are discriminatory in nature, but the law also looks at whether the outcome of the questions you have are discriminating against people. For example, if your process doesn't specifically say, oh, we're going to screen against a particular ethnicity, but you have a process which looks at people's names and screens out people based on names that are uncomfortable or uncommon to the hiring manager, that would be a process that, although it may not be intentionally discriminatory, it has a discriminatory outcome. And so the larger the company you are, the more important it is that you have careful processes in place that do not discriminate against applicants for any reason that is illegal in your state or in the U.S. For some jobs, the employer considers drug testing. If that's you, you'll want to check with your state laws regarding whether you can screen applicants based on drug testing and whether you can even do some sort of drug test as part of your hiring process. Each state has strict laws on this. The difficulty is, what sort of chemicals are you testing for? And are you discriminating against somebody based on perhaps a condition that they have? For example, if they're struggling with alcoholism, let's say, or they're struggling with substance abuse, they have certain rights in some states. And so you don't want to infringe their rights, but obviously you do want to make sure you're hiring people who can do the job in a safe manner. So if you're looking at using any sort of screening or testing for drugs or alcohol or some other behavior, that's where it's important to work with an attorney in your state who is very familiar with your state's employment laws. Similarly, you may want to do background checks for the position that you're hiring. Some positions, like those working with children, it's irresponsible not to do a background check to see if a person has any sort of criminal history or other history that would make them a risk to children, for example. But there are often strict state laws related to how you can do background checks, what sort of notice or consent you have to get, and the strict processes for that. The whole idea behind these states' laws is to protect the rights of the employee who's applying for the position. And so some states, like Minnesota, have specific state statutes, so it's important to be on the lookout for that and work with an attorney, or at least research those rules before you proceed with doing a background check. Often if you're working with a background check company in your state, the company itself will know the state procedures and make sure that you're following them so that their company doesn't get into trouble. When you make a job offer to an employee, it's a best practice to have an offer letter. This is a letter that says, here's what we're offering. If you're asking the employee to sign a non-compete agreement, non-solicitation agreement, or confidentiality agreement, or if there's any other contractual requirements, it's essential in many states that you have those listed or at least referenced in the job offer letter. It's also a good practice to say in the letter, the employee will be required to review and comply with the employee handbook. Usually the offer letter will say whether the employee is exempt from overtime laws or not, what the compensation will be, whether there's any paid time off or vacation or sick time. Keep in mind, many states have required minimums for paid time off or vacation or sick time. The key to a great offer letter is it includes all the important items that you want clarified up front, but also exudes a warmth and a positivity with the employee coming aboard. Usually the best practice in this is a phone call telling the employee, we're going to be offering you the position, we're excited to have you on board, and maybe giving some basic information. But then the email with the job offer letter is the actual offer to the employee. And that way you have documentation of what that job offer letter actually has in it if there's ever a dispute later on. So keep in mind, there may be required notices in the job offer letter. Those are going to be the non-compete agreement, non-solicitation agreement, or any other contractual requirements that you are asking the employee to agree to as part of the job offer. Another important first policy to establish in your company is a policy against harassment, discrimination, and retaliation. Harassment would be something like sex harassment, some sort of inappropriate sexual contact or sexual comments. Discrimination, that's discriminating against somebody because of the category or classification they're in. And then retaliation. A retaliation policy quite simply says this: if you report improper conduct in the company will not retaliate against you, and the company will not tolerate any other employees retaliating against you. That's an important assurance for an employee in a company, so all employees know that if anything improper has occurred, they can report it without being retaliated against. They'll be protected. Discipline and discharge are other important policies to think about early on in the company. For example, discipline means if you do something wrong, if you violate a company policy as an employee, here's what the consequences are. And then discharge, of course, is when you terminate the employee. And under what circumstances will you terminate somebody? Sometimes companies use a point system. Sometimes companies use like a 3-strike rule. So strike 1 is your first offense, strike 2 is your second offense. You do it again, that's 3 strikes, you're out. What's important with whatever rule or system you come up with is this: make sure that you reserve discretion to escalate the circumstances and even terminate a person after the first incident, if you so choose. Why? Because if your policy says somebody gets 3 strikes and then they do something once that's very bad and you fire them, they can come back and say, you didn't follow your own rules. You said we get 3 strikes. I only got 1 strike and then I was out. You violated your own rules that I was relying on. And so to protect yourself as an employer, if you're going to have a system in place for discipline and discharge, then make sure you at least reserve discretion for yourself. The best practice is just to say, you can find examples online or AI can provide it, but generally, instead of having a system, for most companies, it makes more sense to just say the manager or management will have discretion to impose a consequence that's appropriate for the circumstances when it arises. So in other words, you reserve all discretion to management to make a decision once you have all the facts about what violation actually occurred. Because there are certain circumstances where a single violation is enough to let somebody go. For example, if a person violates trust, they operate without integrity, and you can't even trust them to be in the company anymore, it may not take 3 events. Often 1 event is enough, especially for an experienced manager who knows problematic employees. If you have 1 serious violation of trust, it's better to get that employee out than to have them around and causing other sorts of issues within the company. One other important reminder is every company needs to have in its break room or its common employee area certain posters that are required by law. These posters remind employees of what their rights are. And you might think, well, in the day of the internet, can't they just look those up? They can, but the law still says you are required as an employer to have those posted.